So to go ahead and start out, so anyone lead us in the pledge and Tom to lead us in prayer.
Sure. Everyone stand, please, raise the flag. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let us pray. Heavenly Father, thank you for this day. Dear Lord, watch over us and help us make wise decisions that are in your likeness and to your liking. Forgive us for our sins and bless those who are in need and bless those who serve us. In His precious name we pray. Amen.
Well, she'll tell you.
And we're gonna go ahead and we would approve the minutes from the June meeting. And we'll get started. All in favor? All opposed? Motion carries.
What was that
The minutes from June.
for June? You made the motion,
Kevin,
you seconded
I'm gonna start the copy when it gets around, and it's Max so he can start.
Yeah.
Thank you, sir. All right, Max is on the agenda, so you can come on up. You get 15 minutes, so whenever you're ready, we'll start.
That should be that long. No, this was a question of, membership eligibility for the BZA and the planning board. And, it was brought to my attention by,
Ben Bowling.
Ben Bowling. He said, we was talking to him about the planning commission and, he said that his neighbor was Mark, and I'm, well, I didn't realize that, but I checked him to see if he met the requirements here, but because we did the same thing with Anthony Cypher when he, stepped up to an elected position, and he was no longer eligible to be a citizen member at that time. So we went and looked, to see what was there, but as far as the BZA in, 36-7-4-905, it says you have to either own property or reside within the jurisdictional limits of the board. And the same thing applies for the, planning commission. And the only thing is, about 10 or 11 years ago, Drew Wright come in front of the, commission at the time, planning commission at the time, and they signed the rights of way to the city of Salem for the jurisdictional limits of the 2 mile fringe, which is, so therefore the county can't say that, or the way I'm reading it, we can't claim the 2 mile fringe as being part of the jurisdictional limits that either of these boards have. And that was the issue, but, pretty much in a nutshell, it's up to the board to decide where you're at and what's, going on. But I mean, the state has other things, you can only have 3 people of the same political party, and you can only have, there are different things that goes into this, and it's a pain if you don't read the book, but the question being, down the road, do you get caught? And somebody said they didn't have due process because you didn't have totally legal members all the way around. And if the board's okay, we'll take it. And the thing is too, that we've had a hard time keeping a quorum to do a lot of things. And, I have no problem with Mark. I have no reason, just like the same with Anthony Cypher. I mean, once he wasn't a qualified member, does it actually hurt the board worse than help? Even though you have good input and good things to say, will it be a deterrent down the road when somebody, decides they don't like these ordinances and want to put together that they wasn't, completely above board when these established? So, that's it, I'm gonna answer up to the board that, the concern come up, and the same thing with when Anthony Cypher, when it come up, but, that was it, and the way I'm reading it, the 2 mile fringe is not our, the BZA does not have the right to grant anything in the 2 mile fringe, and neither will the board when you draw your map and say we have a 20-acre minimum, it would not apply to the 2 mile fringe, so. Anyway, thank you. Sorry, good bearer of bad news, but that's, any questions?
Does anybody have any questions?
I mean, that's the two things.
There are, I spent quite a bit of time looking at this. The planning commission,
Could you speak in the microphone, John?
the planning commission and the BZA have jurisdictional authority over roads and streets. That overlaps the 2 mile fringe. So the statute does not define which jurisdictional authority applies. Okay? It says over the area over which the commission has jurisdictional authority. Well, the very example is that resolution that was passed back in 2021 regarding setback. That applies to county roads and streets, part of which are within the 2 mile fringe, and that's a jurisdictional matter that the planning commission and the BZA exercise authority over. So it's my opinion that there really isn't an issue involved it's something that down the road, maybe some legal experts gonna jump up and appeal something, okay?
Well, but the question being like the 60-foot setback, we could give a variance, but we can't give one for any of the 2 mile range.
I think you can.
No.
You think we can? Then any question that comes up to the city, they have to defer to us on road setback distance?
The city ordinances on subdivisions take precedence in the fringe, but jurisdiction on the county, the city does not control the county roadway. The city's not out here blacktopping roads in the fringe all the time. Todd, the city's not blacktopping roads in the fringe.
No.
No, county's
Wish
black.
they would. What's confusing is we have overlapping areas of responsibility. I think some of us are confusing those overlapping areas of responsibility as far as jurisdictional control over whether a board member is eligible to sit on the board. And if you read the first 2 pages of the latest ordinance that addresses this, 2010-05, I can see where it might be a little bit confusing. But the bottom line is, if you go to page 3, that defines the qualifications of a board member for the county plan commission, it clearly states a resident of an unincorporated area of the county. The fringe is an unincorporated area of the county, period. That's what it says. I don't know how much simpler you can get. On page 3.
Pretty simple, maybe.
Well, that's fair enough. It's, I'm reading it the same way I read it when we talked to Anthony, when he actually picked up an elected position. We was told, but it said you couldn't hold as a citizen.
That's a totally different
hold that.
subject.
Yeah, but you're correct, that's.
And if you'd like more
That's.
proof, there's a short paragraph here, I'll just read it to you. This is from the state, it's Indiana Code 36-7-4-211, membership of commission. Notwithstanding any other provision of an area planning law, the representation on any area plan commission may be changed by a similar ordinance adopted by the legislative body of each unit, in this case the county, that is a participant, key word here, that is a participant in a planning department or by the legislative body of each unit that proposes to form a planning department. In other words, the state of Indiana is giving counties, in this rare case, flexibility to do as they see fit, and that's what happened in 2010 in Ordinance 2010-05.
Fair enough.
Anyone else? talk about anything today? We said no, but do you have anything?
I just got a quick comment to make. We're possibly gonna have it won't be for next meeting, but here in the future, maybe by the fall, we might have a new subdivision that will be started here in the county. And just wanted to make this comment. This is coming up quite a bit in my office, on these restrictive covenants we have, the developer presents it to the board and, we look through it. I don't know if it's an actual checkbox on there, but they have the intentions, of people purchasing property, they're gonna follow these covenants. In the past, it's, we've discussed before, it's not happening. My thought is, and I don't know if we can even look into it, for past subdivisions maybe, but, I'm getting calls from residents because, how much development's happening here in the county, and they're concerned with, property they've already bought in the subdivision, they're living there, new people are coming in, they're not really following the rules. And I just wondered if it would be a possibility in the future, and hopefully maybe in the past on some of these, if a developer presents restrictive covenants to us and then they're not followed, if there's something we could present as a requirement for them, if they are not doing the restrictive covenants, that an HOA has to be maintained. If it's not maintained, it then will fall back to the developer.
John's got the answer for that. We've talked about this for a couple of years, and there's one key thing, and that is if it's recorded, the restrictive covenants are recorded with the deed. Now tell me if I'm wrong, that makes it enforceable by the county. Is that not right, John?
If the restrictive covenant is recorded with the deed.
Isn't that what you told me? But there's one little thing that this county has not done in the past that we could require from the developer that would hold their feet to the fire to make sure that the county could enforce their restrictive covenants. Because you told me in the past that the restrictive covenants, as it is now and the way it's been for the past 50 years, is that these are agreements between the developer, the seller, and the buyer. Therefore, they are not enforceable by the county because it's an agreement between a buyer and a seller.
It's not an issue of enforceability by the county. It's a question of enforceability by the neighbor.
Okay, what was it that we needed to do different?
What we needed to do was two things. Make sure that the restrictive covenants are incorporated in the plat
There you go.
Yeah, there you go.
of the subdivision.
Yeah.
And then make sure separately that those restrictive covenants are recorded in the recorder's office and linked to the subdivision.
There you go, that was it.
The problem in the past is that the restrictive covenants were written in the deed,
Plat, it's the plat.
Yep.
but they were never written into and incorporated in the plat.
Yep. Thank you.
So the restrictive covenant is only, in those old instances, it would only be enforceable by the developer against his purchaser. And not enforceable by the neighbor against the neighbor.
plat comes before us, and then it will also need to, be approved by
We're
the,
to make sure that the restrictive covenants are either on the plat or recording information for them is referenced in the plat, and that they are in fact recorded.
So when that happens, you're saying that it's just between the neighbors, it's not enforceable by the county? If the covenants are recorded on the plat or in the recorder's office in reference to the plat, that would be like neighbors holding neighbors accountable?
Yeah.
Is that
If,
what
if
you're
they're,
saying?
if they're recorded on the plat, then it applies across the subdivision. And one neighbor can enforce it against the other now. But-
Without an HOA?
Yeah. Because that becomes a covenant that runs with each and every deed.
So they like have to be each other's
Now,
authority?
as far as the county enforcing covenants, restrictive covenants in a subdivision, we'd have to take another step.
What's that step?
Well, we'd have to draft within the covenants a provision that says, you know, these are enforceable by the county in some fashion.
so you need a short one-page ordinance.
One page.
Okay. 1.5. Well, I know Trev's been involved with this a lot and dealt with it a lot, and there've been problems, and we've got lots of complaints about, landowners complaining, not just their neighbors, but the people they bought the property from, and I'm not gonna mention the name, but we all know who it is. They kind of hung them out to dry when they made promises like, the county will pave that road as soon as you and this other guy build a house and you're good to go. That's the biggest problem. They were told things,
And the road was never built to county specs.
and it never happened, and to me, this is to protect the homeowners. So,
So John, do you think you would work on that ordinance? So we can maybe read in the meeting to help Travis out with that?
We're not gonna write an ordinance.
But I mean, whatever needs to be written up, like a draft of what it could look like, so we can see what it should be when it comes in. Okay, thank you.
it's not really his job, but if he could just put some rough ideas.
Yeah.
We'll put you in contact with our county attorney, we'll make him do it.
Yeah. I don't know what it would say.
That's why I got a phone call today from Buddy.
John, do you have any items?
I do not.
Okay. So we're gonna move along back to section 516, the solar farm or the commercial solar farm. I just have a quick comment to make. I was typing up some stuff for this that we talked about at the last meeting. And I didn't print it all out because it's really long, but we decided that we were gonna add in the verbiage from the Dearborn County, Article 19. That is 15 pages long. I don't know if you all knew that at the time that we said we would do that. And it has different categories. So I did not type it all up to match Washington County's because They call theirs a solar energy systems, probably makes more sense. In that idea of things, if you all, I will email this out to you guys, if you all wanna read it and see what you would rather do, we might come back to this topic. But as I was reading it, there's a lot of rules that, or stipulations that need to be followed to do that. And while we were in the meeting, we kind of wanted a lot of rules for it, but not a whole lot of reading material, kind of a short, sweet little thing put together. It's not gonna get both, so,
Can I make a suggestion?
go ahead.
In the wordage that KK had written up, it is basically one full page.
Mm.
So why would we want to adopt something that might have 8 or 10 or 12 or 15 pages when we could go through this and pluck out the things that we know we don't like and go with it? I believe we did talk about it a little bit at the last meeting, and the only sticking point was we decided to change it to commercial because did we decide we don't really want to try to regulate
Yeah,
personal solar? It's not a solar farm, it's somebody with 4 or 5 panels.
yeah,
So we were going to call it commercial.
when I started typing up the Dearborn stuff, it was way longer than the one page that we had, so I thought I'd come back and discuss it with everyone before I substituted it in.
And then I think a big concern among several of us was, Deidre and Will, myself, and Kevin, the abandonment was the biggest issue, you know, make sure that, you know, decommissioning, yeah, that's the right word. It says 12 months, you know.
Would this be kind of like the HOA thing as far as we were talking with the, like the decommissioning issue? Would that need to be written on the plat? If you were doing some commercial thing, it would actually be written on the plat that what it would take in order to tear it down, let's, you know, after 15 years, 20 years. But in order for it to be enforced, would that not be a smart
Well,
thing to do?
I did type up part of Dearborn County's, it's up on the screens right now. It says a decommissioning plan shall be required indicating the method and payment of the anticipated cost of removing the commercial solar farm at the end of their serviceable and or useful life, or upon their becoming a discontinued or abandoned use to ensure that the solar panels are properly decommissioned. Decommissioning of solar panels must occur in the event that they are not in use for 12 consecutive months. And then it breaks it down even farther. The content, the decommissioning plan shall include at minimum the following: the assurance of it, the cost estimates, the final assurance, and then it lists details underneath what each of those are. And then it talks about the discontinuation, and it shall be considered abandoned and or in discontinued use at any of the following that should apply, and there's more stipulations below that. Is that the only little part you guys want to copy over? It's just the abandonment and decommissioning plan from Dearborn County.
Ours has 3 sentences.
Yeah.
I like ours.
I like ours too, but I also, okay, anybody looking at this, is who's determining what the decommissioning plan is.
Mm-hmm.
That's what, is the decommissioning plan just yank can probably get out and take them to the landfill, or is it, what is it?
That's up to him.
Let's give him some guidance. It's up to him. I mean, I don't know what that plan would look like.
We're in uncharted territory.
I understand that, we're about to get in charted territory here, what this one is working on. Somebody's gonna have to chart territory. They're gonna come, somebody's gonna come in, they put one in and say, well, what's a decommissioning plan? Okay, does the manufacturer have a decommissioning plan? Refer to manufacturer, I can't read that.
It basically just says that it's about the cost of removing it, how much it's gonna cost, the money's gonna go in an account, so that it's there for later. I never really specified in the Dearborn County one what the decommissioning plan was per se, but I got to when I was typing this up.
Somebody has a decommissioning.
So, if you all would like me to look it up.
Manufacturer does, or somebody does, I don't know.
There is a piece of the Dearborn County plan that refers to waste management, not specific to the decommissioning, but in regards to any waste that would be generated, including equipment, parts, packaging, operations, maintenance. And their wording there is, in a manner consistent with industry standards. If you want to take that very
There you go.
broad stroke of the brush.
That's okay.
That's, flexibility.
But it refers you back to some sort of standard.
Yeah, which is really all we need.
All hazardous waste generated by the operation and maintenance of the facility, including but not limited to lubricating materials, cleaning materials, batteries, etc., shall be handled in a manner consistent with local, state, and federal waste disposal rules and regulations, and shall not be allowed to seep into the ground or come in contact with any open water.
Yeah, which is really what we need.
What I was at,
If we refer back to state
some standard.
and federal standards, then we're good.
So you could almost copy that.
So we just add that little piece.
I don't know that the way it's written here, the way that it's titled in here, is specific to that, the decommissioning. Because they refer to it as waste management, not decommissioning.
Kind of related.
Here, I'll try one.
We can put that, can we just put that statement, to be read as part of 516.13 decommissioning, could we add that to that?
Probably, yeah.
It's around page 11, subsection.
Somehow or other.
Put that whole thing under there. 16. I'm gonna try something real fast.
management and solar.
Waste management in regards to,
The decommissioning.
Decommissioning. The decommissioning aspect of it, only decommissioning.
Waste management.
Management out.
Yeah.
Stick it in there and be done with it. Decommission.
Didn't take waste management out, I mean, just
Yeah,
interested in.
It's green, and there's no problem with it.
The waste from it is not green.
That's why that's a really long paragraph, but.
so a decommissioning plan shall be required to ensure that facilities are properly removed after their useful life. Decommissioning solar panels may occur in the event they are not used for 12 consecutive months. All solid waste, whether generated for supplies, equipment, parts, packaging, operation, maintenance of the system associated with facilities, including old parts and equipment, shall be removed from the site in a timely manner consistent with industry standards. All hazardous waste generated by the operation and maintenance of the facility, including but not limited to lubricating materials, cleaning materials, batteries, etc., shall be handled in a manner consistent with local, state, and federal waste disposal rules and regulations, and shall not be allowed to seep into the groundwater and contact with the open water.
One thing on that Dearborn County thing that I like, it says, the county may hire any consultant and or expert necessary to assist the county in reviewing and evaluating applications or plans. And then the applicant will be reimbursing the county for that hiring. So I haven't, didn't know if that was in our other draft, if that was something that we thought we might want to include, because none of us are experts in knowing how to do that.
Good point.
So that would be reimbursable from the applicant.
That's what it says in the Dearborn County.
Does it say anything about the person's qualifications? Can you read that again?
So, what page is that? 13. So it says the county may hire any consultant and or expert necessary to assist the county in reviewing and evaluating what they call their applications. And basically it just talks about how the applicant would reimburse the county. They use an escrow fund.
Is this for construction or decommissioning?
Well, this one talks about construction or modification. I would say that decommissioning is a modification.
I would assume our, current, 516.10, it requires a site plan, obviously prior to decommissioning plan. So I would assume that it would be both, the decommissioning plan would be part of your, site plan that's required prior to construction. I think my issue with, what you're bringing up, Danielle, is this would not only pertain to solar farms, there's all kinds of, things that could come to this county that, somebody in Travis's office may not be an expert on. I think that a statement like this would be better, be more of a general statement. If we're gonna require reimbursement from developers, I don't think we should just limit that to solar farms. And I guess at the same time, I don't know that it needs to specifically
clarification, this kind of relates to what she just read on who's footing the bill for the decommissioning plan. All it says is decommissioning plan shall be required. Do we need to put in there at the owner's expense, or, I mean, is somebody gonna read this and assume that Travis is gonna come up with a plan? Plan shall be required. I mean, that leads you to believe that it's on them, but doesn't make it real clear.
If you look at just a quick Google search definition of decommissioning plan for a solar farm, essentially it is, and this is kind of obvious, I guess, but it's removal of all equipment and waste, and then returning it back to, that land back to a usable state. So all the way up to reseeding that area, so that it can be reused for whatever it was out for.
Removal of all equipment and waste, what you said?
Yeah. Removal, grading, seeding disturbed areas, additional costs associated with the removal, so hauling fees and it looks like that gets up into several $1,000s. Removal of equipment and restoration of the site. And maybe that's a simple way of wording that. The decommissioning plan would include removal and restoration.
Now we need a restoration plan.
I wonder if, and I don't mean to make work for Travis's office, but, you know, if you're gonna build a fine feeding operation in this county, there's ordinances that you're required to go through. There's also an application process that they go through your office. And through the application process, everything that you would fill out would be referenced back to these ordinances, I would assume. So if we just have a decommissioning plan shall be required, if you were to type a document up, maybe with some guidance from us that lists out what is required in that decommissioning plan, I think we would be covered there. We don't need to list out everything that's needed in that decommissioning plan in this document, but they just need to fill out a form that the county provides. And that form may have the site plan, decommissioning plan, questions about other conflicts and other regulations, aviation protection questions on that application.
So the decommissioning plan would be part of the original permitting process, is that what you're saying?
Yes.
And if that happened, would it be smart, like, you know, you got an outfit that's an LLC, right? 15 years, 10 years, 5 years, they're gone. they're just, they evaporated, they're they're not there. So when this thing goes south and needs to be maintained or needs to be taken down, there's no money, there's nobody responsible. Wouldn't it be smart that somebody would make a reasonable guesstimate on how much it would take in order to tear it all back down, like Deidre says, back to farmland or back to a usable thing, at least at this point in time? And that amount of money would be put in a bank account for that specific, you know, for that to be, looked at down the road. Because otherwise, the taxpayer has to eat it up, I guess. Why would we want to do that? It's kind of like this, covenant thing, you know. So you that didn't check it out, you know, if your covenant's not on the plat, then, you know, you don't have anything. So why wouldn't we have something, you know, that money could even be bearing a little bit of interest, maybe just a little bit, just enough to keep up. I don't know, probably wouldn't keep up with inflation, but at least there'd be $10,000, $25,000. And if you're looking at a place like Duke Energy or somebody like that, that's no money for them. But why would I let anybody put up anything just because they wrote out a plan? Because they can just walk away. And who has to pick that up, or who has to see that eyesore? But it seems to me, it's kind of like a no-brainer, common sense, but.
The state just passed a bill in February. Senate Bill 4, talking about that very thing. Readings up here, but the way I understand it, you have to bond, or have money set aside for the decommissioning. 25% of the total cost of the decommissioning has to be done within the first 5 years. And then 10% of that, or 50% of that within 10 years. According to this bill.
And this relates specifically
This
to
is
solar.
state solar, yeah, commercial solar energy systems, it says. And I think that's due mainly to, there's a couple of big solar farms going in up north, and I think they went in and changed some things around to cover themselves statewide, so I guess we could refer to that
I agree.
bill as well.
Cover it.
Yeah, Senate Bill
Minimal wording and
411, which was adopted and approved in February of this year.
read it, email that to me,
Yes.
and I'll get it, whatever. Thank you.
So in other words, we don't have to put that in our ordinance, we just have to.
Reference.
Reference that,
As part of the,
that's state law.
let's put it in. That works.
I'm gonna throw out a wrinkle.
Heaven.
It's not that solar then, so what does that do for us for them on treating operation? You got 4,000 here,
Right, a whole nother,
another 10-1, didn't it? 4,000 head feeding operation goes broke. Is that them pits are full? What happened? I just started to think about that. Move on.
It's gonna get bought out by someone bigger.
Probably.
I'm gonna say it's IBM,
Yeah.
have any kind of,
They may have, I'm not putting any kind of feed out there, so I don't know.
Or is there a health department concern?
well, actually, the state, when I was reading into this a little further, they require 25% of the
later than the start date of the solar operation system's full commercial operation.
Wow.
So they have to have 25% upfront, 50% within no later than the 5th anniversary of the start date, and 100% within 10 years of the start date. So it's pretty defined in that bill. And it's long as well, though, and if you probably wouldn't want to copy the whole thing, you can just reference it.
Just reference the.
Reference bill number, the,
The bill number.
Let's see here, it's 411.
They just adopted that about a year and a half ago because.
February, I think it was February of this year. That also refers to wind power devices.
Yeah.
Same thing on that as it does with the solar.
That's about it, isn't it?
I don't have any questions about it.
That was signed by the governor on March 11th, 2022.
You guys wanna move on to section 517, telecommunications facilities? Short ones?
are we gonna revisit 516 at some point?
Yeah, I'm gonna edit it and I'll bring it back, I'll email it out, or I can, bring it back up at the next month's meeting, we can approve it and send that on once I get it done.
Great.
The telecommunications facility. Is there any changes you'd like to make, just let us know.
Are you considering 517? There should be some reference in there to the airport.
I believe there is in another section.
Height ordinance.
I think, I would assume it would address security fencing as well, same as Solar Farms does. I don't know if I know of a tower that doesn't have security fencing, and maybe that's just, at the,
Discretion of the.
It's because it says new antennas on existing towers. This is not newly constructed towers. Existing alternative, existing. It's not talking about, they're assuming that
One's already been approved and this isn't out.
anything that's built new is already going to have fence. That's the way I see it.
is there a section on, another section on telecommunications facilities? I'm not aware of.
One, I think, you'll be addressed under that.
What number did you say?
521,
Okay.
525, yeah. No, that's tower and setback, so I don't know if that addresses Hannah a little bit. But that's in wind energy section.
I think this is covered in another section, and it's not sure.
That's wind energy, I apologize, that's not wind.
Amateur radio and television radio receiver antennas. It could be part of it. It's in here somewhere.
Five oh three,
503.
amateur radio. Maximum height. But that's not.
John, do we need to say anything in there about, you was talking about the airport, when everybody knows that anything to do with an airport is trumped by the feds, and they're the ones, you can't just throw up a tower close to an airport, it's gonna interfere with landing and taking off.
Well, there is a,
I mean, what I'm saying is there's already federal regulations out there that address towers. And of course, this is just referring to antennas.
well, there's a specific county ordinance that's been adopted.
Airport overlay ordinance.
Airport overlay.
Yeah, well, that's my point, yeah.
That sets limits on the height of towers or other structures
Yeah,
within prescribed distances from the center line of the runway.
that's what I thought. So,
503, the sentence there refers to, specifications are also subject to the airport overlay ordinance. So it just references that.
You just want it in those sections so that we don't have to.
Is there a number for that specification, airport overlay ordinance, that could be incorporated in that?
It's a separate,
Right, but if we could put the number in there.
We can dig it up.
yeah, it's a separate.
So you just wanna
It's already adopted.
just wanna reference it in 517 called Goodman? Is that what you were, is that what you were saying?
Copy that. Scroll through it.
It's got to. Somebody wrote Washington County, Indiana, doctor,
Just moved it in.
Just move this one down.
So John, I pulled up ordinance, it says an ordinance establishing an airport overlay district. Is that what you're,
not, yes.
yes? So,
And the number is,
ordinance number 2014-09. And then, sorry. You could just say airport overlay district or something like that in parentheses, so that way they know if it's.
Well, the specifications are also subject to the airport overlay ordinance 2014-09.
Makes sense.
Yeah.
You don't have to read it.
Sorry.
Yeah, but I think we probably need to go up and put that piece that we just done in parentheses,
To the top.
up in 503.
I thought we just take this out. That's basically the same thing. And it's for the airport overlay district ordinance.
Airport overlay district.
So, what the, what was it?
Yeah, great.
Okay. And there you go, 503.
Let's say anything that deals with height.
Is that okay with everyone else if we make them both match?
yes.
Okay.
For me.
just a telecommunications facility? Even though this is just for the new antennas, do you still want the name to say telecommunications facility?
I think it's misleading,
Like Andrew said.
It seems like something was cut from this.
Yeah.
there should be.
Yeah.
I don't know that, and while you have the screen ready, I don't know that you could copy and paste, section 516.14, copy that whole paragraph and put it in 517. That would make sense to me in telecommunications as well.
516 what, .4?
114, one conflict of other regulations, which is addressing what you brought up earlier, Todd, about, if the FAA already has, regular requirements, it doesn't preempt that, whatever is, more restrictive, shall cover.
More restrictive, it seems like there's something going on in that.
Yeah.
Like that.
You guys still think about it, maybe just change that, maybe, it's not really new telecommunications facilities, but
Change the name to existing, is that what you're saying?
not really existing, but like additional, it's just if you're adding on, right, a new antenna, it's already there, you're adding a new antenna to the, so modifications to telecommunications facility,
Or update,
yeah, something like that,
whichever one sounds best.
yeah, whatever word you use sounds better. Cause it is kind of,
Modify.
yeah, but it is for now, if there's something better, we can change it.
I think something we brought up in the past is these titles are pretty generic, because in the future they may be added to.
Yeah.
So if you just leave it, if you leave it more broad, you can add more, in the future.
So leave it back as kind of this thing.
That's what I said, but
So it creates a category.
Yep, took it out. So we like to just,
Then you get decommission too?
it has a sentence on there, did you see that, Kevin?
yeah,
I did. Shall be removed by the property owner.
It's, that's a, yeah.
Yeah, it's like.
but would it go under this if you're adding a new antenna, or would it go under the original setup of the facility, the decommissioning plan? This is just, you're gonna add a new antenna on. It's not the whole initial permit process.
I think what he meant was, if you get too specific in the title, then you're gonna have to get more specific in the wordage.
If you go to the little bitty section I have about this, it's like this big, and I don't think there's anything in there.
So Dearborn County has a telecommunication,
They have what?
they have a telecommunication ordinance that's 16 pages long.
Are you serious?
Yeah,
Who does?
Dearborn County, the one we just looked at for, yeah. Like solar, so,
Yeah.
I think that's
It's all like it's,
There,
not that cycle.
eBay.
yeah, somewhere in there,
There
it's
doesn't
in that
show-
general proximity.
Is it on the second one? Yeah.
Thank you.
Yeah.
They're getting encroachment from
They got a lot of Cincinnati regional stuff.
yeah.
Would y'all like to make any further changes or move on to something else? Or leave it for now? Do some homework on it, come back to it next week.
I don't think we have to talk about it right now, because we got.
Yeah.
Not a lot of time, but I feel like if we need to decide if we wanna put anything in about new telecommunications facilities or not.
Yeah.
I mean, yes or no, if we do, then we need to think about it pretty specifically, if we don't, then modifying what we already have is sufficient. But I would say that we're more likely, I think, to have telecommunication facilities built in Washington County than wind facilities.
Yeah.
So if we are gonna go down a little ways to wind, and we're gonna have 3 pages, then we probably ought to have more than 3 sentences for telecommunications. Not that I wanna have 3 pages for any of it.
Yeah, I agree. Considering there already is dozens of towers already.
Hundreds, yeah,
I don't know enough.
they're everywhere.
Well, I know,
But I
There's
can
more
sit
than you
here
think.
and write things that, I mean, I don't know how tall those towers are, or how tall they should be, or,
Yeah.
Like I said, it makes sense to have to require a fence to be around them, but.
Federal walls,
Yeah, it might be
you
worth
know, there's federal walls, because these puppies are sticking up in the air, you know, red lights on to look like eerie at some point in the night, but.
Someone's regulating the force.
Yeah.
Is there any regulation on, or should we have any regulation on where you can put them in the county?
on their part.
There never has been between the landowner and the company.
But that's our job, is to say where they can be or can't be, or they have to go to the BZA. So if we're okay with it going everywhere, then let's just say that. In our, right?
I would assume that most things are covered, like, you said that, with the federal regulations, height requirements and
But-
even fencing.
But
Because I'm thinking
where-
solar towers,
where they're put is not.
but where is not.
We can regulate that.
That's our job.
You have a farm that has a high point and it's prime for a cell phone tower, but it happens to be adjacent to a subdivision, is that someone will be upset if there's a new tower built in the side adjacent to residences.
Sure.
How about we'll do the same thing with this, like we did sexually oriented business, before the next meeting, I'll look up some different things and send it out to everyone. Or somebody else could volunteer to look them up and send them out to everyone. You know, it is what it is, I'll just think as it is.
That'd be great.
Okay, so let's pass on this and we'll look up some stuff and email it out, how's that? Do you wanna stick with the adjoining counties like we have been doing, or do you wanna reach farther out?
It's been working pretty good, hasn't it?
Close counties, okay.
So like, and then,
Other counties' regulations and looking at them.
Like last time, I just looked at the adjoining county, that we don't need to stick with. Okay.
zone area and you can have these, we say you can have these.
Is that those sharp things?
Yes, and if we said no, that you don't want it there, then you have to go to the BZA and get a thing. Was there something like that about telecommunication?
Are you talking about this thing?
Yeah, I can't keep up with paper, I'm sorry.
You're fine. I don't know what this was. This is my first call on the board. You're more than welcome to read it. Yep,
Floyd County, so you have to look at.
Floyd County?
Yes.
okay. Any others that you think would be good to look at?
Floyd and Clark.
Clark, okay.
Yeah, the towers or what they have. Like Clark County Airport, when you always take off there, you know, they had the antenna farm off to the left there, you always had to watch out for.
All of that, all of them, you know, deal. I'll be proactive.
And Floyd County, same thing.
Okay.
Wireless communication facilities permitted across the whole thing. You agree? So we can do it everywhere. Well, let's see, what does it say? This means. Yeah, permitted use.
All of those.
Well, that's this.
Is that because maybe the federal regulations are so tight that it limits how you can put them in those zones, maybe? Alright. Slide, did you hear that?
Yes.
On that chart thing we made for KK a long time ago, it's permitted in all the zones.
Okay, what?
Hours are permitted in all zones, based on that chart we did for KK.
Unless we wanna tweak it, right?
For each listed use key, so a black key in the box means that use is allowed by right. So I don't know, we have black keys in all of them. And red key means change special exception to permitted use. So like radio or television towers, we have red keys across the whole thing.
Meaning it's kicked to the BZA, right?
We changed it from the BZA having to give a special exception to us just permitting it. If it's red keys.
Well, the whole point is, as long as we're aware of it, then we can regulate it, right?
And we'll just stick with the homework, and we'll see what everyone else is kind of saying. Would you all like to move on to the next section, or